It happens constantly across America, and most people don't realize they've just crossed a legal line until they see flashing red and blue lights appear behind them, and their entire life is about to be destroyed over a technicality nobody ever explained. You're retired. You're finally seeing the country the way you always dreamed. Your RV isn't just a vehicle anymore. It's your second home, your weekend retreat, maybe even your full-time residence. So naturally, you treat it exactly like a home. You park it for the night, extend the awning, lock the door, and keep a loaded firearm within arm's reach just like you would in your own house. And the vast majority of the time, you're completely in the right, because here's what matters. When your RV is fully parked at a campsite, hooked up to utilities, engine off and functioning as your residence, many states treat it as your castle, which means castle doctrine applies. A loaded firearm under your bed is perfectly legal in most jurisdictions. A defensive response to a threat at your door falls fully within your constitutional rights, just like if you were home. But the absolute second you turn that ignition key, everything flips in ways that can send you to prison. That castle becomes a vehicle under law, and now you're dealing with an entirely different legal framework that nobody at the RV dealership or campground ever bothered to explain. This is about 10 gun rights built specifically for older Americans in February 2026. Real legal protections, massive fee reductions, waived requirements, and training exemptions that exist in federal and state law right now. But the system doesn't advertise them. Gun stores won't mention them. Licensing agencies stay silent. Even advocacy organizations that claim to fight for your Second Amendment rights keep these benefits buried where seniors will never find them. Why the deliberate silence? Because when you don't know your rights, when you overpay for permits you should get at half price, when you take training classes you already earned the right to skip 50 years ago, somebody else profits directly from your ignorance. And one of these 10 protections could literally be the difference between walking free after defending yourself and spending years fighting criminal charges that destroy everything you've built. These aren't loopholes or legal tricks. These are rights you've earned through decades of responsible gun ownership, through military or law enforcement service, through simply reaching an age where lawmakers decided you deserve recognition. But they've been deliberately kept quiet because an uninformed senior citizen generates more revenue than one who knows exactly what they're entitled to under law. If you're tired of being treated like your decades of experience don't matter, if you're furious about watching younger gun owners get advantages while you've been paying full price for rights you earned generations ago, subscribe to this channel immediately and turn on notifications. What I'm exposing today is information that gun retailers, government licensing offices, and even Second Amendment advocacy groups actively avoid promoting, because the moment you understand these protections, their profit margins take a direct hit. Don't let them keep winning. Subscribe right now, and let's drag into the light exactly what they've been hiding from the Americans who've earned these rights more than anyone else. Here's the reality about recreational vehicles that almost nobody explains until you're already facing criminal charges and your attorney is telling you there's nothing they can do. When your RV is fully parked at an established campsite, when it's connected to utilities, when the engine is completely off and you're using it as your living space, many states treat it under residential castle doctrine laws. That means a loaded firearm kept under your bed for home defense is perfectly legal in the vast majority of jurisdictions. A defensive response to someone threatening you at your door falls fully within your constitutional rights, exactly the same as if you were in a traditional house. But the instant you turn that key and the engine fires up, everything changes in ways that can result in felony weapons charges and the permanent loss of your Second Amendment rights. That castle becomes a motor vehicle under state transportation laws, and now you're operating under an entirely different legal framework. That same loaded shotgun that was completely legal 90 seconds ago now must be unloaded, locked in a secure case, and stored in a manner that makes it completely inaccessible to you while the vehicle is in motion. If it's within reach and accessible when you get pulled over in the wrong jurisdiction, You're not looking at a warning or a citation. You're looking at felony weapons charges that will strip your gun rights permanently. Think about how absolutely insane that legal distinction is. The same firearm in the same physical location becomes legal or illegal based solely on whether your engine is running. Thousands of retired Americans travel this country every year in recreational vehicles without anyone ever explaining that this legal minefield exists beneath their feet. They assume the rules remain consistent whether they're parked at a scenic overlook or driving through Wyoming. They're dangerously wrong. The critical takeaway here is brutally simple but could save you from prison. Treat your motor home as a vehicle when it's in motion and as a residence only when it's fully parked and serving as your living quarters. One wrong assumption about which legal framework applies, one moment of confusion that any reasonable person could experience, could transform a peaceful retirement road trip into a criminal prosecution that destroys your Second Amendment rights forever. And here's the part that should make your blood boil. Campground staff won't warn you about this legal trap. RV dealerships won't mention it when they sell you a $250,000 luxury motorhome. You're just expected to somehow know, and when you don't, when you make an honest mistake that millions of Americans could easily make, the full weight of criminal consequences falls entirely on you with no mercy and no second chances. Now here's something that could save you hundreds of dollars and eliminate hours of completely unnecessary bureaucratic hassle. And it reveals exactly how state governments profit from seniors not asking the right questions. That hunter safety card you earned decades ago, maybe back in the 1970s when you were still a teenager, that yellowed certificate you probably haven't thought about since bell-bottom jeans were fashionable, might be the only documentation you actually need to qualify for a concealed carry permit today without taking another training class. A surprising number of states still accept state-approved hunter education certificates as completely valid proof of firearms competency for concealed carry permits. Doesn't matter if it's from 1978. Doesn't matter if portions were handwritten by an instructor who's been dead for 30 years. If your name appears on it and it came from a certified program, you may be able to skip the expensive concealed carry class entirely, skip the mandatory range qualification, and skip the complete training portion of the permit application process. States like Wisconsin, Virginia, Idaho, Arizona, Oregon, and several others have it written explicitly in their regulations. Hunter education counts as valid training, and not a single one of them advertises this prominently anywhere. Why the deliberate silence? Because every time a senior forgets about that old certificate or doesn't know to ask if it still holds legal weight, the state collects another $100 class fee, another processing charge, another registration payment from a taxpayer who's overpaying for training they already completed successfully when they were 17 years old. This is where older gun owners possess a massive advantage they don't even realize exists. You already learned how to handle firearms responsibly through actual field experience. You've been hunting, cleaning, storing, and carrying for decades without a single incident. You passed rigorous safety testing when training was conducted with live ammunition and firm instruction and real consequences, not sanitized PowerPoint presentations in air-conditioned community centers. So before you sign up for another 4-hour lecture from someone half your age teaching you skills you mastered before they were born, call your state's concealed carry licensing office directly. Ask them explicitly, does my hunter safety certificate from decades ago qualify for concealed carry training credit? Because that piece of paper sitting in your basement file cabinet might still carry more legal weight than you ever imagined. And if it does, you just saved substantial time, significant money, and a massive amount of bureaucratic hassle by being properly trained before most of today's instructors were even conceived. Walk into virtually any gun store in America today, and you'll notice the exact same pattern playing out. Paperwork stacked everywhere. Background check systems processing constantly, employees moving at maximum speed to cycle customers in and out as efficiently as possible. That's the modern retail pace, and it accelerates dramatically when staff see someone over 60 walk through the door. The pressure starts immediately and builds relentlessly. Just sign here. It's all standard procedure. Are you finished yet? We have other people waiting. But what they will absolutely never tell you, what you'll never see posted prominently on any sign anywhere in the store, is that if you're over 60 years old, federal law is explicitly on your side. Under the Americans with Disabilities Act, seniors possess the legal right to reasonable accommodation during the firearms purchasing process. That includes additional time to complete required forms, assistance understanding complex legal language, reading help for fine print sections, or clarification about what you're actually signing. And this protection isn't optional or dependent on store policy or employee goodwill. It's federally mandated law with serious penalties for violation. Hearing loss, slower information processing speed, vision impairment, needing assistance to properly complete ATF Form 4473 is not a character weakness or something you should feel embarrassed about. It's a protected status under federal disability law with the full weight of the Justice Department behind it. And if a gun store employee rushes you, pressures you to move faster, or treats you like a problem customer because you need 5 additional minutes to ensure the paperwork is correct, they are the ones breaking federal law, not you. In Arizona, there's a documented case where a 72-year-old man was nearly denied his constitutional right to purchase a handgun simply because he was taking longer than staff preferred to finish the required paperwork. The employees made him feel rushed, unwelcome, and treated his reasonable pace as an unacceptable inconvenience to their business operations. But once he calmly cited his ADA right to reasonable accommodation, the store's entire attitude transformed instantly, and the transaction was completed properly within minutes. The truth that nobody in retail wants to acknowledge publicly is that most gun shops won't bring up this federal protection because time directly equals money. Slower transactions mean fewer sales per hour, and if properly accommodating an older customer means the next person in line has to wait an extra 7 minutes, they'd strongly prefer you didn't know you're legally entitled to that accommodation. But none of that business pressure or profit motivation changes your constitutional rights even slightly. If you're purchasing a firearm and someone is pushing you to move faster than you're comfortable with, you say one sentence clearly, and you only need to say it once. I am requesting reasonable accommodation under federal disability law. Watch how rapidly the tone changes because the moment you invoke that federal right, the pressure stops immediately and federal law steps in directly behind you, protecting your interests. Now, let's expose one of the most infuriating examples of how major advocacy organizations profit directly from seniors not asking uncomfortable questions. Most gun owners over 60 have spent more money on ammunition, range time, training courses, and organizational memberships than they want to calculate. You've supported Second Amendment rights actively for longer than some of these younger gun rights activists have been alive. But here's what almost nobody will tell you, and what these organizations desperately hope you never discover on your own. Some of the largest gun rights advocacy groups are quietly offering you absolutely massive discounts and actively hoping you never ask about them. Take the NRA as the most blatant example of this deceptive practice. They offer something called a Distinguished Life membership designed specifically for people 65 or older. If you qualify based on age, you can lock in a lifetime membership for $500. Sounds like a decent rate until you realize the standard price charge to anyone younger is $1,500. That's a $1,000 difference based solely on having lived more years, and they're absolutely not advertising this aggressively in any of their membership recruitment materials or direct mail campaigns. And the NRA isn't alone in this practice. Gun Owners of America, the Second Amendment Foundation, and multiple other major organizations all offer similar senior-specific membership benefits and price reductions. But not a single one of them shouts these savings from the rooftops or promotes them prominently, because the brutal truth is that full-price memberships generate substantially better revenue when people don't ask difficult questions about age-based discount structures. Before you dismiss this as just getting a membership card and a window sticker, understand exactly what these memberships actually provide. Monthly magazines with current legislative updates and legal analysis, access to comprehensive training materials and educational resources, significant product discounts at major retailers, participation in legal defense funds that could prove critical if you're ever charged criminally, and sometimes even specialized firearm insurance options that could save you tens of thousands of dollars if you face criminal or civil charges related to a defensive shooting. So this matters enormously, both financially and legally. Here's the part that should make you absolutely furious. These organizations typically will not volunteer information about the senior discount structure unless you specifically bring it up and demand they explain the pricing disparity. That's why this protection is critically simple to claim. If you're over 60 and considering joining or renewing membership in any gun rights organization, ask directly and explicitly. Pick up the phone or compose an email and state clearly, do you offer a senior citizen discount on lifetime memberships? Watch the quoted membership price drop dramatically in real time once they realize you actually know the discount exists and you're demanding they honor it. You've paid your dues to these organizations literally and figuratively for decades of loyal support. There is absolutely zero reason to continue overpaying when the discount structure was built into their membership system the entire time, but deliberately kept quiet to maximize revenue extraction from uninformed seniors. If you're beginning to understand just how much critical information about your own legal protections you didn't know, if you're realizing how many substantial rights and financial savings you've been leaving on the table year after year because nobody in any position of authority bothered to inform you they existed, then subscribe to this channel immediately and activate notifications. Because upcoming videos break down the precise legal language to use when police officers ask about firearms during traffic stops, the specific insurance programs that could save your financial future after a defensive shooting, and the state-by-state analysis of senior exemptions that could save you thousands of dollars annually. Don't wait until you're facing criminal charges or financial devastation to start learning this information. Act now while you still have time to prepare and protect yourself properly. Every single year, thousands of retired Americans walk into sporting goods stores and state licensing offices and pay full price for their hunting licenses, game tags, special stamps, access permits, the complete regulatory package. They hand over $100, $150, sometimes $200 or more. And the absolute worst part that should enrage you is that in numerous states, they didn't legally have to pay a single dollar. That's not hyperbole or exaggeration. In states like Florida, once you reach 65 years old, your standard driver's license automatically becomes your hunting and fishing license by law. No special application required, no additional paperwork necessary, no separate fees, you're simply covered completely. Turkey tags, deer tags, waterfowl permits, the entire package waived permanently. You've earned it through age alone under state statute. But nobody behind the retail counter is going to hand you an informational flyer explaining that you just massively overpaid for something that was already free under law. In Georgia, if you were born before January 1st, 1961, not only do you skip the hunter education requirement entirely, but you also automatically qualify for deeply reduced licenses or completely free ones depending on which specific permits you're seeking. Dozens of additional states follow similar statutory models with quiet exemptions, hidden discount structures, and age-based benefits buried in regulatory footnotes on Fish and Wildlife Agency websites that the vast majority of Americans will never read or even know exist. Why does absolutely nobody talk about this publicly or advertise it prominently? Because most licensing systems are deliberately constructed to charge fees first and answer clarifying questions later only if specifically pressed. If you don't know to ask the exact right question, they're certainly not going to interrupt the transaction to explain how you just substantially overpaid for privileges you qualified to receive free under existing law. Many seniors simply assume they must follow the identical process as everyone else because nobody in the government bureaucracy bothered to inform them otherwise. But here's the truth that actually matters. State legislators created these senior-specific exemptions because they understand that most older hunters are demonstrably more responsible and experienced than younger participants, and they're typically living on fixed retirement incomes. It's written explicitly into law as formal recognition of your decades of safe hunting practice and contributions, but it's deliberately hidden behind bureaucratic silence because informed citizens generate less revenue than ignorant ones. So here's exactly what you must do. Before you pay for your next hunting license, navigate directly to your state's Fish and Wildlife Agency website. Search specifically for senior hunting exemptions or any regulatory language tied to your birth year. You might discover that the license you've been loyally paying for year after year was already legally yours, and nobody in the licensing office ever mentioned it because your continued ignorance was generating consistent government revenue. Now, here's where the financial exploitation of seniors becomes even more egregious and indefensible. Every year, older Americans walk into county sheriff's offices and state licensing bureaus ready to renew their concealed carry permits, and they hand over the full application fee without any questions. Not because they're legally required to pay that complete amount, but because nobody ever informed them the price drops dramatically after reaching a certain age threshold. States like Louisiana have it written explicitly into statute. If you're 65 or older, you pay exactly half of what everyone else pays by law. A 5-year permit that costs $125 for a younger applicant drops automatically to $62.50 for seniors. A lifetime permit option that normally costs $500, it's $250 for seniors. And these aren't temporary promotions or obscure bureaucratic loopholes. They're law, formally written into state policy and deliberately ignored when nobody asks the correct questions. Alabama rolled out lifetime concealed pistol permits recently. The standard cost is $300, but if you're 60 or older, you pay exactly $150. Identical permit, identical legal privileges and protections, just half the cost based exclusively on your age. And Texas provides reduced renewal fees for seniors across the board, but you would absolutely never know this exists unless you read the dense regulatory fine print or knew precisely what question to ask the licensing clerk. That's the fundamental structural problem. These discount programs exist, they're completely legal, they're active right now in February 2026, but they're not advertised anywhere visibly or promoted in any meaningful way. Licensing departments don't display informational signs explaining senior rate structures. Most official government websites don't clearly explain the age-based pricing systems or make them easy to find. If you don't independently verify the fee policy or ask directly and explicitly about senior discounts, they will gladly charge you full price and proceed with processing your paperwork without ever mentioning you substantially overpaid. For seniors living on fixed retirement income, these cost reductions matter enormously. You're not requesting charity or special favors. You've spent a lifetime following the law meticulously, maintaining proper training and certification, and renewing your permits responsibly on schedule. What you're entitled to isn't a discount. It's formal legal recognition that you've already earned the right to pay reduced fees after decades of perfect compliance. So, before you submit an application or renew your concealed carry permit, contact your state's licensing office directly. Ask explicitly and clearly about senior citizen rates and available discounts. And critically, ask about lifetime permit options, because if you're still paying the identical fees you paid 20 years ago at full price, the probability is extremely high that the state government has been extracting more money than the law actually requires them to collect. If you served as a sworn law enforcement officer for at least 10 years and retired in good standing, you may already possess one of the most powerful concealed carry privileges available anywhere in the United States. And there's a disturbing likelihood that nobody ever properly explained it to you or ensured you understood how to exercise it. It's called LEOSA, the acronym for Law Enforcement Officers Safety Act. and it was passed federally in 2004. It grants qualified retired law enforcement officers the legal authority to carry a concealed firearm in all 50 states, regardless of restrictive local or state-level permit requirements. That means if you live in a highly restrictive jurisdiction like New Jersey or California, where regular citizens often cannot obtain a carry permit under any circumstances, LEOSA completely overrides those state restrictions. It's a federal right explicitly protected by statute, and states cannot legally deny it or impose additional barriers. To qualify under LEOSA, you must have served a total of 10 years or more as a sworn law enforcement officer with full arrest powers. You'll also need to obtain and carry official photo identification from your former agency and complete an annual firearms qualification course, similar to what active duty officers are required to pass. Once those straightforward conditions are satisfied, you do not need any state-issued concealed carry permit to carry lawfully in any American state. But here's what's actually happening across America in February 2026. A substantial number of retired law enforcement officers simply never apply for their LEOSA credentials, not because they're disqualified or ineligible under the statute, but because they genuinely don't know the federal program exists, or they mistakenly believe they must follow the identical permit system as regular civilians. Some states have even brazenly attempted to require retired officers to navigate local permitting bureaucracies anyway, despite clear federal law. But when those state requirements have been challenged in federal court, judges have consistently and decisively ruled that LEOSA stands above state law and cannot be circumvented or overridden by local restrictions. This isn't a creative loophole or questionable legal interpretation. It's explicit federal protection specifically created for those who served in uniform and earned these expanded rights through years of dedicated service. If you meet the qualification criteria and want to carry across state lines or in jurisdictions with restrictive carry laws that exclude regular citizens, this federal protection matters enormously. Contact your former department's Human Resources Division or Training Unit directly and request specific information about obtaining LEOSA credentials and completing the annual qualification requirement. You may already fully qualify for nationwide concealed carry under federal law, and simply not exercising these credentials means you're voluntarily abandoning a legal right you worked your entire career to earn.